Hey everyone, we have our friend Saul Goodman to thank for this clip. Over in Kansas, attorney Tara Morton got in a little bit of trouble. It seems she copy pasted her website, but forgot to take the other firm's name off of it. So when people were searching for the other firm, her site was coming up, and they weren't too happy about that. This led to the bar looking into her and finding a few other things that she kind of didn't do right either. I have had this clip on my to-do list for over a year now. I was waiting on the order to come out, and then I was waiting on the right time to show it to you. And you know what? I decided today is the right time. So let's go to the Kansas Supreme Court.
Thank you, Your Honor. The 1:30 p.m. docket for Wednesday, September 13th, 2023 consists of one case, appeal number 125621 in the matter of Tara D.D. Morton, original action and attorney discipline. We are ready to proceed, Your Honor.
Thank you, Mr. Shima. Counsel, would you please state your appearances and for the record?
May it please the court, Gail Larkin, disciplinary administrator, appearing on behalf of the Office of the Disciplinary Administrator, present and ready for argument.
May it please the court, Tara Morton, I appear pro se.
All right, thank you. Ms. Larkin, you may proceed.
Thank you. This is an original action and discipline filed by the Disciplinary Administrator's Office against Ms. Morton. The respondent was admitted to the practice of law in Kansas on July 8, 2016. On June 16, 2022, the Disciplinary Administrator's Office filed a formal complaint against the respondent, alleging violations of the Kansas Rules of Professional Conduct. While the respondent filed motions, objections, and affirmative defenses, she did not timely file an answer to the formal complaint. After the Disciplinary Administrator's Office filed a supplement to the formal complaint, the respondent filed, that same day, the respondent filed an answer to both the formal complaint and the supplement to the formal complaint. In her answer, she admitted some facts, denied others, but denied violating the 3 rules of professional conduct as outlined in the formal complaint. On August 23rd, 2022, a hearing panel of the Kansas Board for Discipline of Attorneys held a hearing on the formal complaint. The hearing was conducted by Zoom. Because counsel to the Kansas Board for Discipline of Attorneys had a conflict, a former board member, Nick Badgerow, served in that role. He also appeared by Zoom. At the conclusion of the hearing, on behalf of the Disciplinary Administrator's Office, I recommended that the respondent's misconduct warranted disbarment. On September 20th, 2022, the hearing panel entered an amended final hearing report memorializing its findings of facts, conclusions of law, and recommendation for discipline. The hearing panel concluded that the respondent violated the 3 rules outlined in the formal complaint: KRPC 7.1, communications concerning a lawyer's services; KRPC 8.1, bar admission and disciplinary matters; and KRPC 8.4, professional misconduct. The hearing panel recommended that the the respondent's license to practice law be indefinitely suspended. The respondent took exceptions to the amended final hearing report, and the parties briefed the issues. Turning now to the facts which gave rise to the formal complaint. This case arose from issues regarding the respondent's website, her Kansas bar application, as well as several Colorado bar applications. In November 2020, Kansas attorney Brandon Davies of Roth Davies discovered that the respondent had copied significant portions of content from his firm's website and pasted that content onto her website. As a result of the respondent's actions, when the term Roth Davies was searched in an internet search, the respondent's website appeared in the results. In addition to a reference to the Roth Davies name and telephone number, that also appeared on the respondent's website. In November 2020, Mr. Davies sent the respondent a letter by certified mail, as well as an email message asking her to remove the Roth Davies content from her website. The respondent did not respond to Mr. Davies' communications. A week later, he again demanded that the respondent remove that duplicated content by email message. Again, she did not respond to his communication. The email messages that were sent to the respondent's correct email address. During the disciplinary proceedings, the respondent asserted that she did not receive any of the communications sent by Mr. Davies. The respondent's website included many pages of the Roth Davies website, including legal analysis and case summaries developed by Roth Davies. The respondent's use of the Roth Davies website made it appear that the content was the product of her labor and experience. On her website, she also identified herself as an experienced attorney practicing in the areas of criminal defense, personal injury, and workers' compensation. Contrary to her assertion that she was an experienced attorney, she had limited experience practicing law. She had been licensed for only 4 years. For at least a portion of 2016, she was employed full-time as either a school teacher or a school principal. And her practice during that time was limited to the evenings and weekends. In 2020, the respondent described her practice at that time as relatively small legal practice. In her February 2021 response to the complaint, she stated that in November of 2020, she had no criminal cases, and at that time had previously only handled 1 criminal case. In that same response, she stated that she had not taken any new cases in any practice area until the close of 2020. In addition to describing herself as experienced on her website, she also indicated that she copied and pasted the logos of bar associations when she was not in fact a member of those associations at that time. She copied and pasted the Martindale-Hubbell AV rating logo on her website, and she had not been rated as an AV lawyer through the Martindale-Hubbell service. In fact, she wasn't eligible for that because she had only been practicing for a few years. On January 11, 2021, Mr. Davies filed a complaint against the respondent with the disciplinary administrator's office. After receiving the disciplinary complaint, the respondent disabled her website. While Mr. Davies' complaint remained pending, our office learned that the respondent had a pending bar application in Colorado. We also learned that she had failed to disclose the Kansas bar complaint to the Colorado admissions authorities. As a result, Tom Stratton, then Director of Investigations for our office, conducted additional investigation. Mr. Stratton discovered that by July 2021, the respondent had reactivated her website. On the reactivated website, she continued to identify herself as an experienced attorney practicing in the areas of criminal defense, sex crimes, and personal injury. On the July 2021 version of her website, the respondent listed practice areas to include motorcycle accidents and wrongful death cases. The respondent has not handled any motorcycle accident cases or wrongful death cases. Again, the respondent copied and pasted her bar associations or the bar association logos when she was not in fact a member of any of the associations. During the follow-up investigation conducted by Mr. Stratton.
Counsel,
Yes,
can I ask you, those allegations largely support, I mean, maybe a little bit of all the violations, but the false or misleading communication about lawyer or the lawyer's services, is there a mens rea, or what is the intent requirement to support a violation of 7.1, or if there is one?
I don't think that there's any language in the rule which tips its hat as far as what the mens rea is. I do think there's sufficient evidence in this case, though, to establish that the respondent engaged in knowing conduct involved in the 7.1 violation. Specifically, knowledge can be inferred from the circumstances, as this court has said many times. She had complete control over her website. She didn't hire anybody else to draft her website or post anything on her website. She had complete control over that. She knew what was on there. She had actual knowledge that she was not a member of the associations or had not received the award from Martindale-Hubbell. She knew she was not an experienced attorney. I think I've outlined the different pieces of that information that establish her lack of experience, specifically with those practice areas where she had never handled any cases or had handled only one case. During the hearing on the formal complaint, she talked about her experience and how she based a lot of her experience on the fact that she worked as an intern for the public defender's office while in law school. She took down her website in 2021, but put it back up in July 21 with some of the same offending material. And finally, she knew that she had cut and pasted information from Mr. Davies' website without doing the research and writing herself. So she was aware of all of those things. I do believe that the one kind of element that cast doubt on her knowledge was her belief that it was not a live website, her belief that it was somehow hidden from the public. That's something that's, I think that's one of those things that you could certainly take judicial notice of. The fact when when, someone can Google something and find it on the internet, she should be charged with knowing what is out there, knowing what she's posted, and knowing the effect of that post. When Mr. Stratton conducted additional investigation, he compared the 2019 Colorado bar application with the Kansas bar application, and many differences were discovered. First of all, the employment history varied from application to application, and most significantly, on the Kansas bar application, she omitted her employment with the Boys and Girls Club, while she did disclose that on the Colorado bar applications. That's relevant and material because she was fired from that position for engaging in fraud and for theft from that organization. Specifically, the fraud and the theft kind of took two different types. On one occasion, in December of 2007, she requested a check payable to the Sam's Club in the amount of $3,000. She took that check to the Sam's Club, purchased some items for her own personal use, and applied that check toward those items and applied the balance to the Boys and Girls Club account. The value of the items that she purchased for herself totaled about $400. In addition, while she was employed as a regular employee of the Boys and Girls Club, she basically paid herself twice. She had a salary and she also paid herself hourly. The value of the double payment exceeded $4,000. To date, she's not paid back the Boys and Girls Club either the $400 from items purchased at Sam's Club, nor the $4,000, which she obtained by fraud through payroll.
I jump you to the 8.4 findings of the panel.
You bet.
It's both subsection C and subsection G. The findings, I think, are the same for both 8.4 violations. And it appeared from the briefing that both parties agree that 8.4 would not apply to any conduct that predated the respondent's licensure in Kansas. Is that a fair summary of your position?
Certainly.
Okay. And that excludes a lot of the findings I think the panel relied on. Failing to disclose a lot of information on her Colorado application, or failing to disclose on the Kansas application, her employment with Boys and Girls Club, and all of those issues that you just discussed, for example. And it looks to me like maybe we're left with just a few findings to support the violation, including the information that was on the website, the 2019 Colorado bar application that she said she voluntarily resigned from Boys and Girls Club and an investigation revealed no wrongdoing. And she failed to disclose to the Colorado bar that an ethics complaint had been filed against her, the complaint in this action. I'm not seeing any other findings that would have, occurred while she was licensed in Kansas.
I do think
Am I missing anything?
I agree. The findings would be limited to the 2019 Colorado bar application and the website, the false statements on the website. And I certainly talk about the different things that were on the website in the Colorado 2019 application if you'd like, but those are definitely the categories of the dishonest conduct that remains. With regard to KRPC 8.4C, in relation to her website, she engaged in conduct involving dishonesty in 4 different ways. First, she copied that content from the Roth Davies website and pasted it onto her website. That was the legal analysis and case summaries that Roth Davies had developed. She included that Martindale Hubble AV rating on her website. She included the Bar Association logos. And she asserted that she was an experienced attorney when she lacked experience. Sometimes she had either little or no experience in each of the practice areas she identified. And then as it relates to her 2019 Colorado bar application, she engaged in conduct involving dishonesty in 3 ways. First, she included false information about her termination from the Boys and Girls Club. She failed to update her application to disclose the disciplinary complaint in Kansas. Both Colorado and Kansas have an ongoing duty to report or to update the bar application. And once the bar complaint was filed in Kansas, she had a duty to notify Colorado of that. They did not know about that through her disclosure because she did not disclose that. It was only when they asked for information regarding her current status in Kansas that they came to know that there was a pending complaint. And finally, she failed to update her application and she obtained new employment. In fact, during the hearing on this case, she was providing additional information about employment that had not been disclosed up until that point.
Is there any reason to, do we know whether that was material or not? In terms of 8.4, her employment with, was it El Pueblo Boys and Girls Ranch?
I don't know that the El Pueblo Boys and Girls Ranch failure to disclose was material or not. I certainly don't know of any fraud in that employment, but there were subsequent positions that she held that I did not learn about until the actual hearing on the complaint in this case. And so I don't know if there was any issues with those employments or not, but there was the 2019 Colorado bar application was pending for a period of time. And then during that time, she changed jobs and did not update Colorado. So whether it's material or not, I don't know, because we didn't investigate that because it came at the time of the hearing. I see that my time has run out. I will stand for any additional questions, or otherwise I will complete my argument during my rebuttal time.
What is your recommendation for discipline today?
My recommendation for discipline today remains the same as it did at the time of the hearing, and that is I recommend that this court disbar the respondent. Had our office learned about the termination from the Boys and Girls Club during the admissions process, I would have recommended to the Board of Law Examiners that she not be admitted. Whether the Board of Law Examiners would have, how they would have viewed that misconduct, I don't know, but I know that how we would have viewed it. Because she engaged in dishonest conduct in the employment as well as dishonest conduct subsequently, our position is that disbarment is warranted.
Are there any other questions? Thank you, Ms. Larkin. Ms.
I believe
Morton.
that Justice Rosen might have a.
Oh, I'm sorry, I missed it.
I'm sorry, I was muted and I didn't realize that. I'm a little confused, Ms. Larkin. You said you're not using conduct prior to the bar application, but you just referenced conduct prior to the bar application with her employment with the Boys and Girls Club. Can you clarify that for me? Because
Certainly.
she didn't include it in the bar application. You wouldn't have recommended she sit for the bar, but how are you not then bootstrapping that conduct in?
I'm not basing the 8.4 C and G violations on conduct that occurred prior to her admission, but certainly 8.1 takes into account the bar admissions process. And because she wasn't honest in the bar admissions process, the conduct at the Boys and Girls Club is relevant today, and it does constitute a violation of 8.4 C. Not the actual misconduct itself, but her failure to disclose that employment, which would have led to the discovery of that misconduct at the time of the bar admissions case.
I just want to make sure I understand that when you are saying that you would, upon learning about the reasons that she left the Boys and Girls Club, you would have immediately recommended that she not be admitted to practice. That's not what you normally do. What you normally do is you would refer it to a panel, right? I mean, it's a character and fitness issue, correct?
I certainly jumped a couple of steps in the process.
Yes.
But when an application comes in, we would have investigated it. And assuming that the investigation and the character and fitness investigation revealed what the disciplinary investigation revealed, our position would have been this matter needs to go to a hearing. That recommendation would go to the review committee, which consists of 3 lawyers. They would review it and decide whether or not a hearing would be held. And then if they decided a hearing would be held, I would have at the time, because I was the admissions attorney at the time, I would have presented that case to the Board of Law Examiners, and then they would have made a decision about whether or not Ms. Morton would have been admitted.
Thank you.
Any other questions? Okay, thank you, Ms. Larkin. Ms. Morton.
Thank you. Please forgive me, doctors. Um, in the response brief, for the first time, the statements Best Overland Park domestic battery lawyer and Best Overland Park, Kansas criminal defense lawyer appear for the first time. Those statements appear on pages that I've always testified were not intended to be published. I have always taken responsibility for not knowing that unpublished pages could not be discovered online. The 70 pages that were meant for publishing make no such reference. I'm completely aware and took responsibility at the outset that Mr. Roth Davies and other information not discovered appeared on my unpublished pages. When I found out about it, that it was discoverable through his website manager, I immediately took the entire site down trying to figure out why that was an issue and removed all such pages. Mr. Davies did send me a letter, but in the record is that that letter is returned to him unsent. And I'm not sure during the COVID process and online why I didn't see the emails. But surely if I had intended to plagiarize his information and had gotten alerted by it, I would have removed it. And this may not be before the panel. This entire thing may not be before the panel as we sit. The missing positions, as Justice Wall pointed out, including my new positions, have not been shown to be material. A reminder that during COVID, I started working in a document review position, and I have admitted that I was not successfully managing my application, COVID, and my practice. And so for that reason, I withdrew my request to practice in Colorado, got alerted to this matter, and dealt with this exclusively and wound my practice down. The pages that were referenced to motorcycle accidents and wrongful death never any way, in shape or form, referenced my experience in them. In fact, they're just informational pages. And although I disagreed about the use of the term experienced, because I'm not inexperienced, I just have limited experience. And although those pages were informational pages only, I removed those. I think it's important to note the order in which I got alerted to issues. The first complaint, the initial complaint told me about the Martindale Hubble. I do have an active profile with them. I just chose the wrong logo. I do have 4 out of 4 stars, which is what reads on that logo, and I didn't know that AV was different. When they told me about it, I removed it. Also, when they told me about the Roth Davies information, I removed it. After the secondary complaint and then receipt of the formal complaint, I learned of the issues with my saying that I was experienced and the logos. Those were, I admit, were my negligence, and I also removed those and took my website down for a second time. When I produced my website for the third time, I alerted the administrator and the panel. And as we sit here today, never again have any of those things or any new things been at issue. I'm down to maybe 6 or 7 pages on my website now instead of the 70 I had, but that's okay because I want to avoid any issues in the future.
So
Justice Wall, someone became muted again.
I'm out of practice with being online, sorry. So the timeline on the website publication, initially there was some distinction between published and unpublished. Can you first help me understand that just from a technical standpoint? Because I don't know exactly what that means, but.
Yes, I have a website that I do, like Ms. Larkin mentioned, manage myself, and it allows you to create template pages, hidden pages, and then pages that you actually click published on, which you expect for the internet to see. And I produced a copy of that was a function of my website during the panel hearing. Those pages you can use just as you're dumping information or as you're drafting new pages to produce. So when I published my website, I found out through this process that in fact those by like web crawlers or I guess just general Google can still be shown if the rights terms are included. So for instance, Roth Davies was included. He didn't discover all of the pages that I had that were not just his information, from which I admitted to in my initial answer. That included like Wikipedia, CLEs, and et cetera. So those all sat on those pages, but his website manager was looking for Roth babies. And so I appeared in the search results, which is how I discovered, and he discovered that that was an issue. So
then-
now, sorry.
Oh, sorry. So then you go through, you redact certain information, and then repost it. And then the second sort of reposting, the disciplinary administrator says it still had, objectionable material on that. And what I was hearing you say but that the material that was objectionable was not previously identified to you as part of the scope of the investigation.
Right, as part of the scope of the initial investigation. And so then the second one came out and the formal complaint. And then I was alerted to using the term experience in my logos. And I lost the benefit of all of those associations the moment those expired. Those were not taken from me. There was no misconduct found. I used them really as backlinks so that my Google search engine would go up. The minute I don't appear in those expired. So if they had clicked any one of those, I lost all the benefit. However, I have taken a CLE that talks specifically about why the general public relies upon associations of that sort, although they are really for the benefit of the lawyer. And I recognize now what a big deal that was. And that I was wrong. So I've always taken responsibility for that. I wasn't trying to defraud anyone. It just was my error.
And then the third posting, which is completely cleansed, was that submitted to and part of the record and before the disciplinary administrator?
I testified
Before the hearing panel, I'm sorry.
I testified to that, and no, and I also alerted them that the third time it was posted that I had reposted it, and no other complaints were brought forward, which they did do. Ms. Larkin did file one supplemental complaint, and I imagine she would have if there were new pages I issued. May I continue?
Yes.
Thank you. I've objected to the subject matter jurisdiction related to my Colorado bar application. My argument against that is plainly and within the cases that Ms. Larkin the administrator relies upon. In her brief, just as in her brief, the frequently referenced cases on the topic include opinions of Crandall, Dennis, Walsh, ESTEP, and the ESTEP courts. At issue in those was whether or not Kansas could regulate attorneys who were practicing law, licensed in Kansas for practicing law outside of the state. There's no issue here about whether or not I practice law outside of state. Rather, this involves my application to the practice of law in Colorado. And this court respectfully has no judicial or police power over my Colorado bar application. And although the administrator wishes this court, to accept Malone, Regent, and Thomas Bellamy on page 19, paragraph 1 of the brief in support of authority to impose discipline on an attorney for statements made on a bar application in another state, each undeniably misses that mark. In each, the respondents were found to have committed misconduct only after they were given the opportunity to defend the allegations in the controlling jurisdiction. Next, the statements made were determined to be materially false, which we have, this court has already discussed, most of them are not. And only then do the outside states consider to take steps to impose reciprocal jurisdiction. Tom Stratton actually conducted a supplementary investigation, which the administrator has referenced, and he learned of my OVL listing related to my Colorado federal practice at the time. He contacted Colorado's Office Attorney of Administration and talked to Don McKnight. Ms. McKnight shared that I was not licensed in the state court. And as I argued in my opening brief, she then exceeded her authority and shared my pending bar applications, which was not substantially similar to the Kansas matters, and Kansas had no authority to otherwise review. As a result, the number of Colorado bar issues were absorbed by Kansas. And I would again argue that Kansas's gain of information there was wrongful. I learned I had a pending application on motion. I learned through this process when Colorado asked me for an updated letter of good standing, because in 2019 I had one, I immediately, the same day, sent an email, which is in the record, to Kansas requesting that letter of good character. I had no idea that my initial contact was in fact reportable and had not resolved in my favor. And so I learned that through that chain of emails, which is in the record. I hadn't had the opportunity because they immediately requested that from me, and I didn't know that Colorado and Kansas had been in communication. I had no idea I had a duty to report that, and it had only days had passed since I had been alerted that it was still an issue. However, I think that is a matter that Colorado has jurisdiction over, not Kansas, and a finding of misconduct. And I say that because I've submitted the final adjudication in another jurisdiction that a lawyer has been found guilty of misconduct would establish conclusively that misconduct for the purpose for Kansas. But conversely, I argue that Kansas 202, KRPC 202 note 5 notes that adjudication of misconduct is binding on Kansas. And until then, this matter is just premature. And even if it was not resumed, withdrawn, or admission was denied, this is not something that under any statutory authority granted to Kansas is automatically reportable to the Office of Attorney Discipline. Never in any case history has a jurisdiction sought discipline based upon a bar application that was withdrawn prior to a finding of misconduct. Similarly, never has a U.S. case history action been taken based on a denial of admission unless egregious circumstances exist, like those in Malone, and then an order from that controlling court was issued that their findings were reportable to other jurisdictions. Furthermore, the administrator seeks to impose its recent findings upon Colorado, which has never been done before in any known case history, to include her own cited cases. That's because the Kansas only has the authority to police the Kansas courts. Finally, I would differentiate this case from the misconduct that was not involving practice of law cases that she cites to, Crandall and Janowski, where this does not involve an otherwise public matter. Bar applications and their details are not for public privy in Colorado or in Kansas. And but for this administrator proceeding with this prong of the action over my multitudes of subject matter jurisdiction objections, the details of my Colorado application would have remained private. That's because policing its own courts, the public is protected in the applicable state when they accept, deny, or admit with conditions an applicant. Thus, no further action is necessary. And I would argue that then that prong of this administrator's case should be dismissed for lack of subject matter jurisdiction. May I proceed?
Yes.
I know I'm running out of time and I'm fearful about that. In due process violations, I stand by all of my prior motions as I do in the subject matter jurisdiction. The administrator and the panel were aware that their sole witness was acting in, that I alleged that the sole witness was acting in retaliatory fashion. And when they denied my mission, they misstated the rule and they suggested that I had more than the 30 days I had had time since January to subpoena records. And that's a misstatement of the rule. And I had only had 30 days, and after regularly requesting records, they denied my singular request for complete discovery. And so then I was not afforded the ability to fully confront nor review unredacted and total documents. Ms. Larkin herself had refused, even though I asked her for those records, even though she was aware her client had threatened me and refused to provide records in the past. She then, only 7 days before the hearing and after they had denied my motions, gently asked her client for records. And then when he re-forwarded the exact same documents and insisted that he had done everything he needed to, she let that matter lie. I know that I'm running out of time, and I don't know if I have the time to address the violations, but I will stand on the idea that there is a culpable state that's written into violations related to 7.1A and 8.4 C and G, that it's very clear, but the legislation is requiring by the words that they chose more than just negligence or knowledge, as I have admitted to. That's because the ABA shows that this is not that administrative disciplinary actions are not intended to punish, but rather to police and protect the public. And that their experience has shown that when these matters can be cured and have been, that the public is typically protected. I'm all out of time. I haven't gotten the opportunity to argue my mitigating circumstances, and I'm wondering if I can be given grace to do that.
Yeah, yes, I think we asked questions and Ms. Larkin ended up with more than her 15 minutes. So I'll just do it this way and ask you what your mitigating circumstances are that you would present to the court.
Okay. I would ask that reprimand and on the alternative probation or suspension stayed by probation be the outcome of this case. I'd like to ask the court to not take my arguing for exceptions as a refusal to accept responsibility. If I could go back in time, I would have disclosed, from what I understand now, I would have flushed out my temporary employment placement at the Boys and Girls Club and the related allegations the way I understood them, the way the police had communicated to me. Even though it was investigated fully by the police at least 5 times, James, the witness said, I still would have disclosed them and over disclosed like I did in Colorado. Sorry. I don't know if I answered your question.
Well, could you give me some clarification? I think in earlier filings with this court, Ms. Morton, you suggested that you were winding up your practice and you're not going to practice anymore. Is that still what's occurring, or do you intend, or is it your desire to continue to practice law with a Kansas license?
I desperately want to practice. I'm really good at it. And I enjoy it. And so when my mental health compounded with COVID and my kids and all of these things became overwhelming for the sake of my clients, and I wound my practice down. My goal is not to practice the same way in Kansas because it requires me to appear in court more frequently. And I know that that's cost prohibitive, at least right now for me, but my maintaining this license impacts whether or not I can practice closer to home. And so my goal and my intention is to accept what the outcome will be for this and have the opportunity to move on. This is my life's work.
And you reside in Colorado still, is that correct?
Yes, Your Honor.
Okay, no, thank you.
I would ask that a reinstatement hearing and suggest that would be more of a punishment. In practice, supervision or suspension doesn't protect the public. My bar application, the allegations related to the Boys and Girls Club, the worst part of this, are 16 years in the past. All other issues have been resolved. I missed the 10-year cutoff by 9 months. It was 9 years and 3 months old. I had no reason to urgently apply to Kansas. My son didn't graduate from high school until the following fall, and I have no other ties to the state of Kansas. Had I known, and I was gainfully employed after being in law school in a non-legal way, I had every reason that if I needed to wait the extra months, I just made a mistake of dates like I did through all of my applications, and I'm responsible for that. And I know that.
May I ask a question?
Yes.
I want to understand that the reason that you didn't disclose the Boys and Girls Club, because it was within the 10 years, was because the question asked about employment and you believed it was temporary employment, and
Yes.
so it wouldn't qualify.
Right.
Okay.
And so I had more than one job with TSO PEO. So you'll see on there, I had multiple titles and multiple positions. My employer was the temp agency. My placement was at Boys and Girls Club, and I was placed in several other places by that agency. And so
did you put any of the other placements on the application?
No, and in fact, on my Colorado application where this was discovered, the question actually asked, was I ever terminated from employment? And I marked yes, and then explained, although I wasn't terminated from employment, this was a temp placement. I'm disclosing this to say what happened at my placement and my time during the Boys and Girls Club. And this was before I ever knew that whether or not I was a temp or a permanent person was an issue. And I don't know that I misunderstood the rule, but I know that I now would do it different. And also, I'm horrible. When I did all these applications, I was terrible with my dates, and I've owned that. I made a chart. I made so many mistakes about just trying to get generally based on my life events when I was employed, and I missed that mark just barely. So
And then for the Boys and Girls Club, were you prosecuted for that?
No, there was a full investigation, police report. In fact, one of the reporting officers was the Boys and Girls Club board member, and no probable cause was found. He, even up to 2021, was saying that he was asking for prosecution in the matter. I hired an attorney. My attorney told me that the matter was not going to be moved forward. And that was the last
So of course it wouldn't have come up under, you know, any kind of, have you ever been charged with a crime? Because you were never charged with the crime.
Never arrested, never arraigned, never brought, nothing. The only thing I had was the police contact, which on none of those applications asked that. But in Colorado, because I knew for sure then it was not 10 years old, I flushed that position out and said, and in fact, Ms. Larkin asked me on my 2019 Colorado application why I didn't remove that information, because it was 10 years old by then. And that was because I had already disclosed it in prior ones and it was auto-populated. I did make amendments to the section to say that my lawyer had told me that it was resolved, and it wasn't. And it was. I never was prosecuted after that fact. And I don't want to challenge more than I put in my brief, but Mr. Sullivan refused myself and Ms. Larkin to provide documents in support of showing I was employed before that time, that I importantly had knowledge that I had changed positions. He says there was no contracts, there was no conversation.
That's fine. I just wanted to know that. I appreciate your answer.
I would like to say to the court that my colleagues, who are often white and men, have been afforded probation and or short-term suspension for a definite period of time, as outlined in my opening brief, even where there were facts of theft from their clients, lying to law enforcement, criminal convictions, dishonesty, and etc. That was oftentimes by joint stipulation, that they were offered less than what I'm being positioned with, that the administrator is asking for here. Obviously, both the admission, the attorney admission to the bar and the oversight that we receive once we're admitted is meant to protect the public. I don't think that you can argue that the circumstances here related to my admissions are worse than the acts committed while someone is licensed. In fact, I would argue the opposite. I think this would represent a gross injustice and be disproportionate to the case precedent to even ask that I would be indefinitely suspended under the circumstances, given how far and remote all of the allegations are, and that I've never had a complaint by a client or any other employer before or after the Boys and Girls Club related to this, and that all other issues are resolved. I would just quickly tell you that my mitigating factors are that I don't have any prior disciplinary action. I've always cooperated with this process and been forthcoming and taken responsibility and made corrections. In fact, even my brief was said to be horrible. And after I read Ms. Larkin's beautifully written brief, although I had a sample brief, it was nothing like what hers was. And so I asked to rewrite the brief, which was denied, and I accepted, but I did submit a sample brief to show that I can receive feedback and apply it. I have provided a couple of character letters, and one of them's from my son, who worked in my office. And I've asked some of my opposing counsel if it didn't conflict with their position for letters, but I ran out of time. I also submitted a letter from my prior employer while I was in law school, which shows that I had more experience in courts and in briefing and assessing cases. But she also then spoke to her opinion of me, which was not requested as a character letter, but I submitted it just to show that. And she offered me the opportunity to work with her if that's possible. I've expressed remorse and embarrassment, and I still stay on that. I expect that it'll be really difficult, if not impossible, to get my Colorado license, and that's where all my family are. And that's where all my ties are. I do volunteer and I offer services to people who are oftentimes minorities and don't qualify for the public defender, but can't afford really expensive counsel. I give free advice to people who call me from Kansas where I can. I have an open scholarship available for, Kansas college students. I just have never gotten any applications about that, but I have donated books and materials and supplies during my time. Just two more things, I think. I've secured a practice mentor in the state of Colorado because my goal is to practice full-time there. And I submitted proof of that to the panel, or to the justices. I became part of, and I have an actual active membership with the Kansas City Defense Lawyers Association, and I have asked questions of them and sought help even in this matter and taken their feedback. I've retaken the MPRE and passed it since this has happened. And I largely took CLEs related to this and learned so very much more than I could have ever expected. And also that pokes holes in some of my prior arguments, so that I understood that I needed to back off of those, such as display of logos. Yeah, why that was important.
Mr. Steele, Justice Steele, did you have a question?
Yeah, I do have a question. I didn't want to interrupt your mitigating circumstances, but if I could try to understand a little bit better the technical aspects of the website question. And I pulled up your Exhibit B, which is the printout from the Weebly support page. And your website was on the publishing. I don't know what Weebly, the Weebly is a company that produces websites for people, I take it. Is that right?
Yes.
And then you have like a back-end management, content management site that you can log into.
Yes.
And the exhibit that you provided describes hiding pages from your splash page, or hiding pages from your navigation menu, excuse me. Is that right?
Yes, that was the information that they forwarded to me.
So were the pages that you have stated that you believed were not accessible to the public, do you know whether you used that function, that content management function, to hide those pages from the navigation menu?
No, and that's why I shut my website down, because that is the only information they could forward to me, was that if it's on the page, it could be discoverable. But I didn't hide these pages. They were on separate template pages that auto-populated like all the contact information template pages.
But my understanding is you're saying that you believed that those had not been published.
Right. And they didn't have any reference to that except for to say, refer to this spot, and if it's on the page, it can be discovered. If it's on the back end of the page. So no one has ever suggested that someone called me thinking I was Rob Davies. No one else.
From your understanding is that if you have you've got a draft website page that's not yet been published, that can somehow be accessed by a member of the public? That's what.
Yeah. And I had no idea. And there's literally a function at the top of the page when you're drafting them that you click and it's highlighted blue that says publish. Those were all.
Did you, was there evidence in the record? Like, did you testify that you did not publish the pages?
Always. And in my initial answer all the way through, I've always testified that I had no idea that unpublished pages could be accessed by the public. I still don't understand why that could happen, but I messed up and I used them wrong, and I accept responsibility for that.
Okay, thank you. That's helpful to me. I appreciate that.
I currently do document review, and I've just been lately, which is what I was doing during COVID. And so I have oversight. There's multiple attorneys that oversee my work. And that's my sole source of income right now. And it's even limited by project. And so I don't even always have full-time hours. At the worst case, I would ask that I be able to do work where related to that, so that I can take care of myself and my kids. I think that reprimand is sufficient for this to haunt me for a long time, because I will forever have to disclose it, at least for many years to come. And I've cured all the things that I can. And I don't have anything further. Thank you.
Thank you. Any other questions? Ms. Larkin?
Thank you. I want to touch on a few things that Ms. Morton talked about. First off, Ms. Morton talked about Mr. Sullivan, the witness from the Boys and Girls Club. If you look at paragraph 17 of the amended final hearing report, the hearing panel made a credibility determination, and they found that Mr. Sullivan's testimony was credible and Mrs. Morton's testimony was not credible when it conflicted with Mr. Sullivan's testimony.
But is it true, Ms. Larkin, that no charges were ever filed against her?
If you look, I dispute what Ms. Morton said about 5 reports to the police. I saw 1 police report. I'm not certain where the 5 came from, and I've looked in the record in the last few minutes.
Well, I'm not talking about police reports. Was she charged with a crime?
She was not charged with the crime. The Boys and Girls Club, when they discovered the payroll fraud, they reported both things to the police. The police contacted Ms. Morton. She said, I have a lawyer. The lawyer said.
So this is from 10 years ago, and it was reported, and there's never been a crime charged.
That's correct.
It's 16 years ago.
Okay.
It was about.
And so this is something that you're saying that you would automatically say, even though a crime was never charged, that you would automatically say that she never could have come in.
Lawyers have to be trusted. And when someone has engaged in fraud and has stolen from a nonprofit.
There's been no, where are you saying she engaged in fraud? There's been no, this is you saying that.
It's not just me saying that, it's Mr. Sullivan and the records from the Boys and Girls Club.
Right, but the prosecutor didn't even believe there was enough to charge it.
I didn't call up the prosecutor. I didn't look into it.
Well, there's no documentation, right? There's no documentation to show that this was charged.
She was certainly not charged. I completely agree with that. She was not charged. Just because someone is not charged with the crime doesn't mean that the crime didn't occur. And I think that when we have someone who's trying to become a lawyer and be trusted with the money of others, we have to look very carefully at their trustworthiness. And engaging in fraud and dishonest conduct, as I believe has been established through clear and convincing evidence at the hearing in this case, that she basically took $400 when she went to Sam's Club and then overpaid herself $4,000 during the payroll fraud. That to me is sufficient evidence for me to base a request for a hearing and a request that her conduct be looked at closely. I don't think that we should admit folks who have stolen in the past. I don't.
Okay, and then on our bar application at the time that Ms. Morton applied, does it have an explanatory phrase of, what is the 8.1? What did she not disclose about her employment?
She failed to disclose her employment with the Boys and Girls Club.
She did, but she wasn't employed with the Boys and Girls Club. Would you agree with that?
No, I would not. She was employed by the Boys and Girls Club. In fact, if you look at her 2019 Colorado bar application, she discloses Boys and Girls Club as an employer. If you look at Mr. Sullivan's testimony, he talked about how she was initially hired through accountabilities, and then later in September of 2007, she became a regular full-time salaried employee, and she was in charge of their payroll. So she was in fact employed by them. The evidence, and this is one of the things that I think it's really important that you consider the hearing panel's ability to sit as far as credibility goes. They determined that Mr. Sullivan was to be believed on the conflicting testimony. And he
Was there
testified.
any evidence of like a W-2?
If you look at Exhibit 15, there are some paychecks.
Exhibit 15?
And also, if you look at Mr. Sullivan's testimony, he talks about how to kind of interpret those documents and where it establishes the hourly pay and where it establishes the salary pay, and how she paid herself twice. I think it was 3 pay periods, which amounted to about $4,000.
And was in the Kansas bar application, though, the temporary employer was disclosed?
In the Kansas bar application, yes, she put down, I'm not sure the difference between TSO and accountabilities, but accountabilities is the temporary agency that placed her at Boys and Girls Club. And she disclosed TSO as an employer, but she did not disclose the regular employment that she had through the Boys and Girls Club. Mr. Sullivan's testimony, I think, is going to be very key for the court in considering this, as well as the hearing panel's assessment in paragraph 17 of their final hearing report.
Would the temporary employer have knowledge of the alleged events about the overpayment and the cashing of the check? In other words, did that information give your office sufficient, information to reveal all of this through contacting the temporary employer?
I don't believe so. I don't believe that they would have had information about what Boys and Girls Club discovered after or at the time she was let go, just that she was no longer, because they were not employing her at the time of her termination. The Boys and Girls Club was employing her. So that relationship with regard to the Boys and Girls Club had already terminated. And then they discovered the fraud in payroll about 1.5 years later when they were doing an audit of their books and preparing that for the nonprofit paperwork. Additionally, Ms. Morton indicated that she didn't even imply that she had practiced motorcycle and wrongful death, but on her website for the July of 2021, she lists practice areas, and those were some of the practice areas that she included on her website. And that was certainly not in a hidden page, that was on the public page.
Can I ask you about that issue that I was trying to dive into earlier? What was the evidence about hidden versus not hidden, and how exactly that came about?
Well, the evidence would have been what Ms. Morton provided on direct examination from, actually, let me make sure. Ms. Morton did not testify on her own behalf. I questioned her beginning at page 43 of the transcript, and I haven't looked to see exactly what she testified there, but I do think that her position has been consistent since the inception of this complaint, and that is she was gathering information. She thought it was hidden. She didn't know it was searchable. It was discoverable. So I don't have any disagreement with her position about that. And the way it came about was the Roth Davies firm had I'm not sure what the right word is, but a company that reviewed their, that maintained their website and kind of evaluated their presence. And so they would run tests every month to see kind of what would pop up when their name was run. And when they discovered that, it was through a simple internet search of their
Do
law
you
firm.
know, or was there ever any evidence about whether or not these pages, and I'm looking at your exhibit 19, which is the print off the July 30th print off of the website.
Correct.
Do you know whether or not the sub pages, I'll call them, you know, where you have the URL has a backslash and it has backslash about, you know, do you know whether those were linked to from the front page of the website? And was there any evidence about that?
I'm not sure if Mr. Stratton testified about this or not, but that exhibit came to be by Mr. Stratton just searching the internet. So those would all be published pages.
And I looked through the transcript just now real quick, trying to find that. I didn't find anything about that. I guess what I'm wondering is, are there sufficient facts to support the panel's conclusion that this was dishonest conduct or fraud of some kind? Because, and I just can't tell. I mean, as at least I understand the way website publishing works, these were published, but respondents exhibit B from the Weebly help desk does explain that the Weebly owner has the ability to hide pages.
Certainly.
And the way Weebly defines that is they're still live pages, but they are not accessible from your front page. They're not in the navigation menu. In other words, if you don't have the specific URL, you can't get to the page. And I'm just wondering if that accurately describes these pages.
I think we have to kind of consider both the November 2020 website and the July 2021 website. And I think that the November 2020 website, whether it was hidden or not, it was discovered by an internet search. So whether Weebly has accurately described that to what actually happened, I don't know. But
Well,
I know
I understand that it was discovered because you have it and printed it out and so on. But just for the purpose of the question, if a person was trying to build a website and they clicked hide on all these pages after importing what they consider to be a template, which they're going to edit later, without realizing that these pages are searchable, I mean, is that enough to support the violation findings, if those are the facts?
yes and yes.
How? That when there's no intent to put this information in a public-facing format.
I think that we're charged with knowing what our actions have done. I think that it's a know or should have known type of issue. She should have known that it was available. She should have known that what she has done is available and has impacted the other law firm. I think that when she relied on this other thing, and I understand, I completely accept and believe that she did rely on them, but I also think that she's responsible for what she's put out there. July of 2021 is a whole separate matter. She intentionally put that out. That does not obviously have any Roth Davies information, but there was nothing hidden about any of the July, about Exhibit 19. That was all on her webpage.
And which exhibit is the November webpage?
It's embedded in exhibit number 1. And then if you look at Ms. Morton's response, which is exhibit 3, she kind of cuts and pastes and screenshots a variety of things. So exhibit 1 and 3, I think, are the basic places where that is at. This court obviously has jurisdiction over lawyers outside the practice of law. Ms. Morton argued that what she did on her Colorado bar applications is not subject to the jurisdiction of this court. That is simply not the case. I would rely on my brief regarding subject matter jurisdiction with regard to that. In Ms. Morton,
I'm sorry to interrupt you again and taking you back to the website question. Is Ms. Morton's characterization that, you know, from version 1 of the website to version 2, when it was reposted, that the items that were targeted and discussed with your office were removed, and what remained that later became the subject of the violations weren't really made known to her at the time the second version of the website was published? Do you understand the question I'm asking?
I do. I think what happened was it was brought to her attention that there were issues with her website. I do think that some of those issues were pointed out. But I don't think that we necessarily went through every single page and said, you need to fix this, you need to fix that. I think it's reasonable for the lawyer to know what is accurate, what's not accurate.
Well, I wanted to follow up on that also. Page 590 in the record, it's page 4 out of 6 in Exhibit 19. It's the page that referenced motorcycle accidents. Is it the disciplinary administrator's position that a brand new lawyer cannot advertise that he or she will take a motorcycle accident case?
I think that there's an implication that when you say practice areas and you list motorcycle accident, that's an area that you have experience practicing in. I think the implication is experience that just simply didn't exist.
Why? I guess I don't follow that. You pass the bar. I mean, that's what they tell us when we pass the bar. You're qualified to go practice law. Why can't you say, I'll do a sex crime, I'll do an auto accident, I'll do a wrongful death case, I'll do a motorcycle accident case? Why can't you say that?
I think you can say it, but I think the problem is the implication that she's got experience. Throughout her website, both November of 2020 and July 2021, she talked about an experienced attorney she is. And when she lists, where her practice areas and what she's, and you couple that with her allegation that she's an experienced attorney, I think it's reasonable to conclude, looking at that website, that if you've had a motorcycle accident, you should go to her because she knows what she's doing. She's handled these in the past. I think the implication, the inference is there. I think it makes it misleading to the public.
Was this was that the 7.1 violation or the 8.4?
That was, it's dishonest conduct falls into the umbrella of 8.4C because that's the broad violation, but it's a specific violation in my mind of 7.1. One of the statements that Ms. Morton talked about during her argument was that she only days had passed when she was notified that the complaint still remained pending. And that's simply not the case. She was notified in January, February of 2021 that a complaint had been filed against her. She was never notified that the complaint had been dismissed. She had no information to believe that complaint had been resolved in any way. Certainly the investigation had occurred, but she had not received any notification whatsoever about the completion of that complaint. That complaint remained pending, and she should have disclosed that to the Colorado folks.
Okay, explain to me again how that works, that she violates the rules based on that she didn't disclose that a pending investigation. I mean, was there a question on there that said, are there any pending investigations against you?
There certainly is in Kansas, and I'd have to look through the Colorado one to verify that, but I know that they have an ongoing continuing obligation to disclose information.
You're not even sure what the Colorado, so you are tagging her with a violation, but you don't even know if the Colorado asked about it?
Let me take the time, just a moment.
If I may, it's there. And I know that's not helpful to me, but it was just my misunderstanding whether or not I had to report it, if it was initial contact or like an initial police contact, or if there was an actual formal complaint. But in the Colorado bar applications, it did require me to update that.
Thank you for your candor.
And it was certainly an allegation that we made, and it was a conclusion that the hearing panel made as well. Thank you, Ms. Morton. I want to touch briefly on the continuance and the due process argument that Ms. Morton made with regard to the continuance. If she had taken any steps to domesticate the subpoenas, which she had obtained, I had no objection to her continuance, but she had taken no steps to domesticate those subpoenas. She also argued that our office violated her due process by withholding exculpatory evidence. Of course, certainly this is not a criminal case. Brady doesn't apply, but we didn't have any exculpatory evidence. We didn't have the information that we didn't provide to her. Mr. Sullivan provided every scrap of piece of paper that the Boys and Girls Club had, and I provided her every.
Well, no, he did not provide her personnel file, did he?
He did. If you look at Exhibit 15, that's all that was in there. That is the beginning and the end. It has her application. It has her driver's license, her social security number. It has her, I don't know, in a variety of information, but Exhibit
You said
15,
and it has her paychecks in there too?
that was added to after she was fired. It's, kind of the personnel file as far as the termination of her employment as well. So it has the letters that he drafted to
I thought
document.
he refused to disclose something. I guess I must have read the record wrong.
She believes that he had some type of information about the payroll processing company. I think it's exhibits I and J, which were not admitted, but are part of the record. I believe he identifies the payroll company. But he didn't have any more than what is in Exhibit 15. Exhibit 15 represents everything that he had, everything that he provided to me. And it wasn't something that I just provided her a few days before the hearing. I did provide her an additional copy a few days before the hearing that was more legible than what we had before. But if you look at in the investigative materials that she was provided, both in the initial investigation as well as Mr. Stratton's supplementary one, we provided her that information at that time. So
Why was there a need to do one that was more legible? Was the original one not legible?
If you look at Exhibit 15, there's some handwriting, and some of it in a previous copy of it was harder to read, some of the handwriting than the copy that we ultimately used. I think you could read it, but it was more difficult.
If you don't mind, let me jump in real quick. What's our administrative status? I kind of remember somewhere between May and July that there was a question about having to pay the licensing fees, and I think the late fee we waived, but what's our status with that?
Ms. Morton paid her annual registration fee in the middle of August within the deadline set by Chief Justice Lukert.
Thank you.
Any other questions? Okay, thank you to both of you for your arguments today. The court will now take this matter under advisement.
It took the court until December to issue its opinion, but when it did, it published a 35-page opinion regarding the discipline of attorney Tereshawn D. Morton. When the appeals court or a Supreme Court decides not to publish an opinion, it can be used as guidance, but is not binding on the lower courts. When they decide to publish a decision, that is binding on the lower courts, and it has precedental value, either because it is changing something that was already established or because this is a new issue that has never been brought before the courts before. Because this is a published decision, it is quite lengthy. I'll include timestamps for anyone who wants to skip ahead and just hear the order. You can find a written copy of this decision on the Kansas Supreme Court's website, or I will post a copy over on Patreon. So let's get into it. Gail B. Larkin, disciplinary administrator, argued the cause and was on the brief for the petitioner. Tereshawn D. Morton, respondent, argued the cause and was on the brief pro se. This is an attorney discipline proceeding against the respondent, Tereshawn D. Morton of Colorado Springs, Colorado. Morton received her license to practice law in Kansas in July of 2016. On July 16, 2022, the Disciplinary Administrator's Office filed a formal complaint against Morton, alleging violations of the Kansas Rules of Professional Conduct. Morton answered the formal complaint on July 15, 2022. On August 23, 2022, Morton appeared pro se at the complaint hearing before a panel of the Kansas Board of Discipline of Attorneys. Side note, I tried to find these hearings because the rules say that these hearings must be open to the public the same way that district courts are, and I found nothing at all. So I'm not sure where or how these hearings are conducted. After the hearing, the panel determined that Morton had violated KRPC 7.1, Communication Concerning a Lawyer's Services, KRPC 8.1, Bar Admission and Disciplinary Matters, KRPC 8.4, Conduct Involving Dishonesty, Fraud, Deceit, and Misrepresentation, KRPC 8.4G, Conduct that Adversely Reflects on the Lawyer's Fitness to Practice Law. The panel set forth its factual findings, legal conclusions, and recommended discipline in a final hearing report. The relevant portions of that report are set forth below. Findings of fact. The hearing panel finds that the following facts by clear and convincing evidence. Number 8, the respondent is a Colorado resident. She has not passed the Colorado bar examination, but scored high enough on the uniform bar examination in Colorado to apply for and obtain a Kansas license to practice law under Supreme Court Rule 709A. She was admitted on July 8th, 2016. Respondent lives in Colorado, rents an office in Overland Park, Kansas, with a mail drop and a conference room for use on those occasions when she travels to Kansas. I think it's important to clarify that the bar exam is set by each individual state, what the standards are. The uniform bar exam has been adopted by, I think, about 36 states up until this point. Each state has its own requirements on what you have to score in order to be able to be accepted to the bar in that state. There are other states, like, say, Florida, who do not participate in that, do not allow that, and you have to take the individual state bar exam in order to be licensed in that state. Back to Mrs. Morton regarding her website. On November 2020, Brandon Davies of Roth Davies LLC discovered that the respondent had copied significant portions of content from his firm's website and pasted that content onto her own website, www.attorneymorton.com. In at least one place, the respondent included Roth Davies' name and telephone number on her website. As a result of the respondent's actions, when the term Roth Davies was included in an internet search, the respondent's website appeared in the results. On November 17, 2020, Mr. Davies sent the respondent a letter by certified mail and an email message asking the respondent to remove the Roth Davies content from her website. The initial email provided, "It has come to my attention that over 20% of your website is a direct copy or ever so slightly altered content from our law firm's website. In fact, some of our firm's name and telephone number is currently on your site due to the poorly executed copy-paste job. We have spent a lot of time and money in developing our site, and copying the site has affected our search rankings adversely. Kindly remove any of the duplicate content from your site. Our website company will be running a report Friday to check your site for duplicate content." The respondent did not respond to Mr. Davies' communications. A week later, Mr. Davies again demanded that the respondent remove the duplicate content by email message. Again, the respondent did not respond to Mr. Davies' communication. Respondent asserts that she did not receive Mr. Davies' communications. She probably should have checked her spam folder. On January 11, 2021, Mr. Davies filed a complaint against the respondent with the Office of Disciplinary Administrator, after which respondent deactivated her website. As of July 2021, it was discovered that the respondent had reactivated her former website, though it has now been substantially reduced to address the issues discussed below. The 2021 website contained the following intentional misrepresentations by the respondent. The website contained copied substantial portions of the Roth Davies website, including a number of references to the firm of Roth Davies and the firm's telephone number, areas of expertise, and the courts where the firm practices, as well as several case law summaries developed by Roth Davies, making it appear that the work was the product of the respondent's labor and expertise. It is unknown what and how many clients, if any, were misled into believing there was some identity between respondent and Roth Davies, and how many clients, if any, were deterred from proceeding further after seeing the confusion between the two firms. On the website, the respondent identified herself as an experienced attorney practicing in the areas of criminal defense, bad crimes, and personal injury. However, the respondent had limited experience practicing law. In fact, according to the respondent's 2019 Colorado on-motion bar application, and according to the respondent's supplemental response to the complaint and the Kansas bar application, respondent worked full-time for El Pueblo Boys and Girls Ranch and practiced law during the evenings and weekends. And On the website, the respondent made it appear that she was a member of the Johnson County Bar Association, the Kansas Bar Association, and the American Bar Association. The respondent's statements regarding her memberships with the bar associations were false. The respondent has not been a member of the JCBA since 2017. The respondent was a complimentary member of the KBA immediately after her admission in 2016. However, when her free membership expired on June 30th, 2017, she did not join the KBA. The respondent has been a member of the ABA off and on during her 6-year career, but in 2020, when the website was live, the respondent was not a member of the ABA. Respondent has not been a member of any section of the ABA since 2018. Contrary to the information the respondent included on her website, in response to question 6 on the respondent's 2019 on motion Colorado bar application, the respondent stated that she had never been a member of a bar association. On the website, the respondent stated that she received an AV rating from the Martindale-Hubbell Attorney Rating Service. Respondent has not received an AV rating from Martindale-Hubbell. The website claimed respondent was experienced in criminal cases, whereas her response to the complaint, she admitted she had no criminal cases in November 2020 and had only handled one before that. Kansas bar application. On March 2nd, 2016, the respondent applied to take the Kansas bar examination. The application form required the respondent to disclose 10 years of employment history. Because the respondent filed her Kansas bar application on March 6th, 2016, she was required to disclose her employment history from March 2nd, 2006 through March 2nd, 2016. The respondent's employment history included on her Kansas bar application varied from the employment history reported on her Colorado bar applications discussed below. Most importantly, on the respondent's Kansas bar application, the respondent failed to disclose her employment with the Boys and Girls Club. As a result, when considering the respondent's bar application, the Board of Law Examiners in Kansas was unaware and unable to inquire to determine that she had been terminated from her employment with the Boys and Girls Club for misconduct. The panel concludes that despite her protestations to the contrary, respondent intentionally omitted in her Kansas bar application references to her erstwhile employment with the Boys and Girls Club, as she managed to recall and list her employment with a temporary agency which placed her at the Boys and Girls Club with its dates immediately prior to her actual employment with the Boys and Girls Club, while omitting her later employment. This intentional misrepresentation kept the Kansas Board of Law Examiners from checking into that employment, which likely would have led to the disclosure of the respondent's fraud during that employment, discussed below. In addition to failing to disclose her employment with the Boys and Girls Club on the Kansas bar application, the respondent also failed to disclose employment with Colorado State University Pueblo and Crystal Specialists, Inc. In her Kansas bar application, respondent stated none in response to the question whether she had ever received any licenses, when in fact she had been licensed as a special education director and as a temporary teacher. Boys and Girls Club. Respondent was employed by the Boys and Girls Club of Colorado, first as an independent contractor through a temporary agency, and then on September 10th, 2007 as a permanent employee. Her position at the Boys and Girls Club was controller at an annual salary of $35,000. In December 2007, respondent went to her supervisor at the Boys and Girls Club, James Sullivan, the executive director, and presented him for his signature a Boys and Girls Club check for $3,000, which respondent had prepared for delivery to Sam's Club, a supplier to the Boys and Girls Club. Mr. Sullivan signed the check and returned it to respondent. The respondent then went to Sam's Club and cashed the $3,000 check at Sam's Club, which was issued as a payment of the Boys and Girls Club's bill with Sam's Club. Redundancy. Respondent had Sam's Club apply $2,617.18 to the Boys and Girls Club bill and spent the remaining $382 on personal items. Further, the respondent used the Boys and Girls Club tax-exempt account information to avoid paying sales tax on the personal items she purchased from Sam's Club. To date, the respondent has never reimbursed the Boys and Girls Club the $382 which she spent on personal items. While a police report was filed in connection with this theft, respondent was never charged or convicted. On 3 occasions during her employment with the Boys and Girls Club as the controller, the respondent paid herself her full salary as well as wages claimed as hourly employment. She overpaid herself a total of $4,038.35 by this method. To date, the respondent has not reimbursed the Boys and Girls Club the $4,038.35 that she overpaid herself. The respondent was never charged for nor convicted of this theft. The respondent was terminated from her employment at Boys and Girls Club on December 26, 2007. She took her personnel file with her when she left, and when she returned the file upon demand of her former employer, some documents were missing. Again, had respondent's employment with Boys and Girls Club been disclosed on her application for the Kansas bar, these facts may well have been discovered, which likely would have had a detrimental effect on the decision of the Bar of Law examiners. Colorado bar applications. In 2014, 2015, and 2019, the respondent filed a total of 4 bar applications with the state of Colorado. On each of the applications, the respondent disclosed her prior employment with the Boys and Girls Club, which she failed to disclose in Kansas bar application, showing she was aware and recalled it. While the respondent indicated that she was disciplined and left the position involuntarily, she inaccurately explained that she left the position voluntarily and was disciplined only after she voluntarily resigned. She stated that she was investigated for mishandling money. She stated that she hired an attorney out of fear and to protect her rights, and that the attorney found out that nothing ever came of the matter. On her 2019 Colorado in motion bar application, the respondent listed Debbie Uhl, registration clerk for the Kansas Office of Judicial Administration, and the Honorable David Hauber, Johnson County District Court judge, as supervisors of her solo practice. While the respondent was never employed by Judge Hauber or the Office of Judicial Administration, Respondent's Exhibit A shows that a Colorado official asked the respondent to provide the name and contact information of a third-party individual, such as a judge or other professional colleague who could confirm her solo practice. The respondent provided the name of Judge Hauber and Debbie Uhl in response. While in her 2019 Colorado in motion bar application was pending, the complaint which gave rise to this case was filed against the respondent. The respondent failed to notify the Colorado admissions authorities that the complaint was filed against her, as required by the statement of verification portion of the bar application. On her 2019 Colorado in motion bar application, the respondent stated that she had never been a member of a bar association. However, the respondent was a member of the Johnson County Bar Association and the Kansas Bar Association from 2016 to 2017. The respondent was also previously a member of the American Bar Association. Finally, on the Kansas bar application, the respondent disclosed that she worked as a special education director for El Pueblo Boys and Girls Ranch, a mental health and substance abuse treatment facility for adolescents in Pueblo, Colorado. The respondent did not disclose that employment on her 2019 Colorado in motion bar application. Conclusions of law. Based upon the findings of fact, and the hearings panel concluded, as a matter of law, that the respondent violated KRPC 7.1, 8.1, 8.4 C and G as detailed below. The Kansas Rules of Professional Conduct 7.1a provides a lawyer shall not make false or misleading communication about the lawyer or the lawyer's services. A communication is false or misleading if it contains a material misrepresentation of fact or law, or omits a fact necessary to make the statement considered as a whole not materially misleading. The respondent violated this when she published a website containing materially false information, including masses of information copied from the Roth Davies website, leading searchers to land on her website when actually searching for Roth Davies. Her bar association memberships, her alleged Martindale-Hubbell AV rating, and her alleged experience, particularly in motorcycle and wrongful death cases. This was exacerbated when, having removed the website upon receipt of the complaint in this matter, she put the offending website back up within a few months thereafter. As such, the hearing panel concludes that the respondent violated KRPC 7.1a. Rule 8.1 provides an applicant for admission to the bar or a lawyer in connection with a bar admission application or in connection with disciplinary matters shall not A, knowingly make a false statement of material fact, or B, fail to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter, or knowingly fail to respond to a lawful demand for information from an admissions or disciplinary authority, except that this rule does not require disclosure of information otherwise protected by Rule 1.6. In this case, respondent initially failed to include her employment with the Boys and Girls Club, as well as her employment with Crystal Specialties in Colorado State University, Pueblo, in her application for admission to the Kansas bar. Additionally, respondent failed to disclose a number of matters and misstated a number of facts in her Colorado bar to the Colorado bar authorities in her several applications to that bar, including that she voluntarily quit her employment with Boys and Girls Club, that she had not been a member of any bar associations, and failing to disclose that the complaint had been filed in this matter before the Kansas State Board for Discipline of Attorneys. Therefore, the panel concludes that the respondent violated Rule 8.1. Rule 8.4C provides that it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. The panel concludes that the respondent engaged in conduct that involved dishonesty, fraud, deceit, and misrepresentation when she A. failed to disclose on her application to the Kansas bar authorities her employment with the Boys and Girls Club, B. failed to disclose in her application to the Kansas bar authorities her defrauding of the Boys and Girls Club of $382.82 at Sam's Club, C. failed to disclose in her application to the Kansas bar authorities her double payment to herself of $4,038.35 as an employee of the Boys and Girls Club, claiming both salary and hourly wages. D. included false information on her website and then, after receiving a complaint and taking it down, republishing that website, including information taken directly from the Roth Davies website, claiming bar association memberships, and claiming an AV rating from Martindale Hubbell. Respondent's website also falsely claimed that she was an experienced lawyer and could handle motorcycle cases and wrongful death cases, whereas she handled no such cases. Indeed, the website claimed respondent was experienced in criminal cases, whereas in her response to the complaint, she admitted she had no criminal cases in November 2020 and only one before that. E. She failed to disclose on her employment with Crystal Specialties and Colorado State University, Pueblo. F. claimed to the Colorado bar that she had voluntarily quit her employment with the Boys and Girls Club. G. failed to disclose to the Colorado bar that she had been a member of bar associations. H. failed to disclose to the Colorado bar that an ethics complaint had been filed against her in Kansas. And I. failed to disclose to the Colorado bar that she had been employed by El Pueblo. As such, the hearing panel concludes that the respondent violated KRPC 8.4C. 8.4G provides that it is professional misconduct for a lawyer to engage in any other conduct that adversely reflects on the lawyer's fitness to practice law. The following A through I are a repeat of the previous section, A through I, so we're just going to skip that, and the hearing panel concludes that the respondent violated 8.4G. Probation plan. On August 9th, 2022, respondent timely submitted Respondent's Rule 227 proposed probation plan. The proposed plan does not suggest any supervision by any experienced lawyer. The panel finds the proposed plan to be very general and vague, with few specific promised corrections or activities. The panel recognizes that the court is generally reluctant to grant probation where the misconduct involves fraud or dishonesty because supervision, even the most diligent, often cannot effectively guard against dishonest acts. Additionally, placing the respondent on probation is not the best interest of the legal profession and the citizens of the state of Kansas. Further, applying Rule 227, the panel finds that the respondent's proposed plan is not workable, substantial, or detailed, particularly given the remote nature of her practice living in Colorado while maintaining a drop-box office in Overland Park. The panel has found several instances of intentional misrepresentations and fraud on the part of the respondent. Accordingly, the hearing panel concludes that probation is not appropriate in this case, and the respondent's plan is insufficient in any event. Recommended discipline. In making this recommendation for discipline, the hearing panel considered the factors outlined by the American Bar Association and its standards for imposing lawyer sanctions. Hereinafter, standards. Pursuant to Standard 3, the factors to be considered are the duty violated, the lawyer's mental state, the potential or actual injury caused by the lawyer's misconduct, and the existence of aggravating or mitigating factors. Factor A, the duty violated. The respondent violated her duty to the bar and the public by all the misconduct enumerated above. B, mental state. The respondent intentionally violated her duty. C, injury. As a result of the respondent's misconduct, the the respondent caused injury and harm to the justice system and the practice of law in this state. Aggravating or mitigating factors. Aggravating circumstances are considerations or factors that may justify an increase in the degree of discipline to be imposed. In reaching its recommendation for discipline, the hearing panel in this case found the following aggravating factors present. Dishonest or selfish motive. The respondent committed a number of acts of fraud or intentional misrepresentation. Accordingly, the hearing panel concludes that the respondent's misconduct was motivated by dishonesty. Multiple offenses. The respondent committed multiple rule violations. Accordingly, the hearing panel concludes that the respondent committed multiple offenses. Refusal to acknowledge wrongful nature of conduct. The respondent has refused to acknowledge any wrongdoing of any kind and maintains denial and excuses even when confronted with proof. Accordingly, the hearing panel concludes that the respondent refused to acknowledge the wrongful nature of her conduct. Mitigating circumstances are any considerations or factors that may justify a reduction in the degree of discipline to be imposed. In reaching its recommendation for discipline, the hearing panel in this case found the following mitigating circumstances present through neither the disciplinary administrator nor the respondent argued for any. Absence of a prior disciplinary record. The respondent has not previously been disciplined. Inexperience in the practice of law. The Kansas Supreme Court admitted the respondent to the practice of law in 2016, thus the respondent is inexperienced in the practice of law. Application of standards. In addition to the above cited factors, the hearing panel has thoroughly examined and considered the following standards. Disbarment is generally appropriate when a lawyer engages in serious criminal conduct, a necessary element of which includes intentional interference with the administration of justice, false swearing, misrepresentation, fraud, extortion, misappropriation, or theft, or the sale, distribution, importation of controlled substances, or the intentional killing of another, or an attempted or conspiracy or solicitation of another to commit any of these offenses. The lawyer engages in any other intentional conduct involving dishonesty, fraud, deceit, or misrepresentation that serious adversely reflects on the lawyer's fitness to practice. Suspension is generally appropriate when a lawyer knowingly engages in criminal conduct which does not contain the elements listed in Standard 5.11 that seriously adversely affects the lawyer's fitness to practice. Reprimand is generally appropriate when a lawyer knowingly engages in other conduct that involves dishonesty, fraud, deceit, or misrepresentation, and that adversely reflects on the lawyer's fitness to practice. Recommendation of the parties. The disciplinary administrator recommended that the respondent be disbarred. The respondent made no recommendations on discipline other than to plead for the mercy of the panel. Discussion. While the panel is concerned about the multiple acts of fraud, deceit, misrepresentation, particularly on her application, which led to her becoming a member of the bar of this court, and some of which could be considered criminal, respondent was never charged or convicted. However, the panel does not find the respondent is guilty of the serious criminal conduct required to justify a disbarment. Therefore, the panel concludes that indefinite suspension be imposed with the condition that, upon her reapplication for restatement, respondent submit a workable, substantial, and detailed plan for returning to the practice with at least the following provisions. Supervision by an experienced, specifically named senior Kansas lawyer with regular monitoring of practice, advertising, and case handling, and regular reporting to the disciplinary administrator. B, a detailed plan of office administration, client intake and communication, and regular attendance at the Kansas office of the respondent to ensure that Kansas clients receive adequate communication and representation. And additional 5 hours of approved continuing legal education per year on office administration, law office management, and professional responsibility. Recommendation of the hearing panel. Accordingly, based upon the findings of fact, conclusion of laws, and the standards listed above, the hearing panel unanimously recommends that the respondent be indefinitely suspended with the conditions listed above for readmission to the practice. Costs are assessed against the respondent in the amount to be certified by the Office of the Disciplinary Administrator. Now, while that might seem like the end of it, all nice and neat, tied up in a bow, that was actually all the opinion of the review panel, which I can't find any information on. There's one little page that just says that they exist. There's nothing about their meetings, past meetings, even though they're supposed to be open to the public. So I find that a little interesting. Anyways, so now we are on to the actual opinion of the Supreme Court related to the hearing that we just watched. Like I said previously, because this is a published opinion, it is in a lot greater detail than an unpublished opinion would be. So it is quite lengthy. Continuing on. Once a disciplinary hearing panel finds misconduct and recommends any discipline besides informal admonition, the least serious form of discipline under our rules, the matter proceeds to our court. See Supreme Court Rule 226B. At that stage, the respondent and the disciplinary administrator may file exceptions, which are formal objections to the hearing panel's factual findings or legal conclusions. Supreme Court Rule 201H. A party must file an exception to a factual finding or a legal conclusion to preserve the issue for our review. Supreme Court Rule 228E1. If a party files no exceptions, then we consider that party to have admitted the factual findings and the legal conclusions in the final hearing report, Rule 228G. Whether or not the parties file exceptions or briefs, we hold oral argument in disciplinary cases. 228I. Following several rounds of briefing, not relevant to the issues here, we agreed to hold argument by video conference. We did so in September of 2023. Both parties appeared. Morton acknowledged making mistakes, and she expressed a desire to continue practicing law in Kansas. The disciplinary administrator continued to press for disbarment. Discussion. In many of the disciplinary cases we hear, neither the respondent nor the disciplinary administrator files exceptions. As a result, we often adopt the panel's finding of fact and its conclusions of law. In those cases, our task is to decide the appropriate discipline after considering the admitted rule violations, the respondent's state of mind, any resulting injury, and the existence of aggravating or mitigating factors. But this case is more complicated. Morton filed exceptions to most of the panel's factual findings in all of its legal conclusions. Thus, the panel's findings and conclusions are not deemed admitted, and we must determine whether attorney misconduct has been established by clear and convincing evidence. This requires us to examine the panel's findings and applicable professional conduct rules in more detail. Across her exceptions, briefings, and oral argument, Morton raises four main arguments. First, Morton contends that we lack subject matter jurisdiction to discipline her for conduct related to her 2019 Colorado bar application. Second, Morton argues that the disciplinary administrator and the hearing panel violated her federal due process rights. Third, Morton maintains that there is no clear and convincing evidence supporting the panel's conclusions that she violated KRPC 7.1, 8.1, and 8.4C and G. Finally, Morton proposes that the appropriate discipline is probation or published censure if we uphold the rule violations. We address these arguments in turn below. We conclude that our court has subject matter jurisdiction to discipline Morton for conduct related to her 2019 Colorado bar application and that Morton inadequately briefed her due process challenges. But we agree with Morton that the facts and the law do not support many violations the panel found. We also agree with her that the discipline recommended by the disciplinary administrator, disbarment, and the hearing panel, indefinite suspension, is too severe, giving due consideration to the violations supported by clear and convincing evidence, Morton's state of mind, the injury she caused, and the applicable aggravating and mitigating circumstances. We conclude that the appropriate discipline is censure to be published in the Kansas reports. Now, censure is basically, hey, I'm going to tell everybody that you screwed up and I'm going to do this in writing in a publication that everybody reads. And that's all it really is. It's like a public shaming of sorts. It's very odd. But before explaining our reasoning, we must briefly address the supplemental documents Morton filed the evening before oral argument. Those documents include a corrected opening brief, letters of support, and a list of continuing legal education courses that Morton had recently completed. Although we need not discuss the delays in motion practice leading up to oral argument, we twice denied Morton's request to file a corrected brief during that period. Further, under Rule 228C, the record in an attorney discipline proceedings before our court consists of the record before the hearing panel, the hearing transcript, and any exhibits a party offered for admission into evidence at the panel hearing. The rule contains no provision allowing a party to supplement the record with letters of support or other documents the panel did not consider. See Rule 228E1. We do not suggest that supplementing a disciplinary proceeding record is never warranted, but it was improper to do so without leave of the court and on the eve of oral argument. We declined to consider Morton's corrected brief, the supplemental documents, when resolving the issue before us. 1. The Kansas Supreme Court has subject matter jurisdiction to discipline an attorney licensed in Kansas for misrepresentations made while seeking bar admission in another jurisdiction. Morton first insists that our court lacks subject matter jurisdiction to discipline her for statements made on her 2019 Colorado bar application. The hearing panel found that Morton misrepresented facts on that application and that she failed to inform Colorado admissions authorities of the pending disciplinary case against her in Kansas. The panel relied on those facts to conclude that Morton violated KRPC 8.1 and 8.4 C and G, but Morton contends that only the Colorado Supreme Court has the authority to investigate and sanction her for that conduct. We disagree. Article 3, Section 1 of the Kansas Constitution vests the Kansas Supreme Court with the authority to administer the Judicial Department of Kansas government and to exercise judicial power. This power includes maintaining high standards for the practice of law and disciplining those who fail to meet such standards. Thus, under Supreme Court Rule 202B, attorneys admitted to practice law in Kansas are subject to the jurisdiction of the Kansas Supreme Court and the Board for Discipline of Attorneys, and KRPC 8.5, which provides that a Kansas lawyer is subject to the disciplinary authority of this jurisdiction, although engaged in practice elsewhere, specifically contemplates subject matter jurisdiction, even if the lawyer is practicing outside of Kansas. Our precedent likewise confirms that subject matter jurisdiction exists even when the misconduct occurs outside Kansas. Thus, we have subject matter jurisdiction to consider whether Morton's out-of-state conduct, including statements and omissions in her Colorado bar application, violated Kansas professional conduct rules. Number 2, Morton has not established that her federal due process rights were violated during the proceedings before the hearing panel. Morton next argues that her federal due process rights were violated during the panel proceedings in 5 ways. We conclude that Morton has not adequately briefed any of the issues, so we decline to resolve them on the merits. Morton first argues that the panel violated her federal due process rights when it denied her motion to continue the formal hearing. Morton had asked for the continuance so she could subpoena records from the Boys and Girls Club and Sam's Club. To establish a procedural due process violation, Morton would need to show that she was denied a specific procedural protection to which she was entitled. To decide the procedural protections that must accompany the deprivation of a particular property right, we weigh several factors. 1, the individual interest at stake. 2, the risk of erroneous deprivation of the interest through the procedures used and the probable value, if any, of additional or substitute procedural safeguards. 3, the state's interest in the procedures used, including fiscal and administrative burdens, and the additional or substitute procedures would entail. Moreover, respondents in disciplinary proceedings have the burden to show that they were prejudiced by any failure in the proceedings. Morton simply asserts a federal due process violation without addressing any of this applicable framework. Morton next argues that the disciplinary administrator violated her due process rights under Brady v. Maryland by objecting to a continuance and by failing to request and obtain exculpatory evidence on her behalf. Morton does not explain why Brady applies to the disciplinary proceedings. Brady is a criminal law rule. Why the disciplinary administrator had a duty to obtain evidence on Morton's behalf, or why the materials she sought were exculpatory. Morton then argues that the admission of the Boys and Girls Club payroll records and a receipt from Sam's Club violated the rules of evidence. But Morton did not object to the admission of these exhibits. And she merely asserts, without explaining, that the admission of the evidence violated KSA 2022 Supplement 60-245A-B. Morton then argues that the disciplinary administrator failed in her duties to investigate, but Morton does not explain the source of those duties, nor does she explain their substance. Finally, Morton argues that the panel erred by refusing to admit Exhibits I and J that she offered at trial. Those exhibits consist of email exchanges between Morton and the disciplinary administrator, Morton's former Boys and Girls Club supervisor, and the Boys and Girls Club attorney. Morton vaguely asserts that the content of these exchanges conflicts with the supervisor's testimony at the panel hearing, but she does not explain how her argument implicates due process, nor does she explain the alleged inconsistencies or how the exhibits are material or probative. These failings preclude meaningful review of Morton's due process claims. Section 3, clear and convincing evidence supports only some of the KRPC violations found by the hearing panel. In a disciplinary proceeding, we consider the evidence, the hearing panel's findings, and the parties' arguments to determine whether KRPC violations exist and, if they do, what discipline to impose. Attorney misconduct must be established by clear and convincing evidence. Clear and convincing evidence is evidence that causes the fact finder to believe that the truth of the facts asserted is highly probable. In making this determination, the court does not weigh conflicting evidence, assess witness credibility, or redetermine questions of fact. If disputed finding is supported by clear and convincing evidence, it will not be disturbed. In its final hearing report, the panel determined that Morton had violated KRPC 7.1a, Communication Concerning a Lawyer's Services, KRPC 8.1, Bar Admission and Disciplinary Matters, KRPC 8.4c, Conduct Involving Dishonesty, Fraud, Deceit, or Misrepresentation, and KRPC 8.4g, Conduct that Adversely Reflects on the Lawyer's Fitness to Practice Law. Morton denies violating any rule. The disciplinary administrator contends that clear and convincing evidence supports each rule violation, but it concedes that the panel erred by applying KRPC 8.4c and g to conduct occurring before Morton was licensed in Kansas. We address each rule in turn. A, clear and convincing evidence does not support the panel's conclusion that Morton violated KRPC 7.1 by posting certain content on her professional website. Under KRPC 7.1, a lawyer shall not make a false or misleading communication about the lawyer or the lawyer's services. A communication is false or misleading if it contains a material misrepresentation of fact or law, or omits a fact necessary to make the statement considered as a whole not materially misleading. The panel concluded that Morton violated KRPC 7.1 by publishing a website containing materially false information, including masses of information copied from the Roth Davies website. Her Bar Association membership, her alleged Martindale-Hubbell AV rating, and her alleged experience, particularly in motorcycle and wrongful death cases. In the panel's view, Morton had intentionally represented material facts, and her rule violations were exacerbated when, having removed the website upon receipt of the complaint in this matter, she put the offending website back up within a few months. More context is required before evaluating the panel's findings. The record reveals that the disciplinary administrator first took issue with the November 2020 version of Morton's website. Davies had attached screenshots of the page to his complaint, and the disciplinary administrator introduced them as evidence at the panel hearing. The November 2020 website included a logo for the Martindale-Hubbell AV rating, the Roth Davies material, the Bar Association logos, and the statement about Morton's experience and practice areas. At that time, the disciplinary administrator raised concerns only about the Roth Davies materials and the Martindale-Hubbell logo. When Morton received the complaint, she promptly deactivated her website. In July 2021, the disciplinary administrator conducted a follow-up investigation and found that Morton had reactivated her website. It was only then that the office began to object to other aspects of Morton's website. And importantly, in July 2021 version had addressed the administrator's earlier concerns. Morton had deleted the Martindale-Hubbell AV rating logo and the Roth Davies material, a fact that belies the panel's conclusion that Morton exacerbated the violations by reactivating her website. Given that context, it is useful to separate our discussion of KRPC 7.1 violations into two categories. First, we examine the November 2020 website and determine whether clear and convincing evidence supports the panel's finding that the website contained intentional misrepresentations related to the Martindale-Hubbell logo and the Roth Davies material, and if so, whether such findings support KRPC 7.1 violation. Then we ask the same question for the July 2021 website concerning the Morton's bar membership and her experience and practice areas. Number one, clear and convincing evidence does not support the panel's conclusion that the content of Morton's 2020 website violated KRPC 7.1. Clear and convincing evidence does not support the panel's findings that the use of the Martindale-Hubbell AV preeminent was an intentional misrepresentation. There is no dispute that Morton had not received that rating, but the records show only that the logo was on the website for some time until a complaint was filed, that Morton promptly removed it, and that she did not republish it on her July 2021 website. The disciplinary administrator argues that we should infer that Morton knowingly violated the rule simply because she controlled the content of her website. But we cannot agree. No evidence suggests that Morton's use of the logo was intentional, as the panel found, rather than inadvertent and negligent. And the disciplinary administrator has not argued that lawyers are strictly liable for KRPC 7.1 violation, or that a lawyer may violate the rule by way of ordinary negligence. Therefore, we reject the panel's conclusion. Nor do we agree that Morton's use of the Roth-Davies material violated KRPC 7.1. The rule prohibits a lawyer from making a false or misleading communication about the lawyer or the lawyer's services. But Morton's inclusion of the Roth-Davies material, whether inadvertent or intentional, was not a communication about Morton or his services. Instead, it consisted of summaries of Kansas and federal case law, a question and answer section about Kansas domestic violence law, and an explanation of the criminal trial process. Perhaps Morton's use of the materials violates a different rule of professional conduct, a possibility we address in part below, but KRPC 7.1 is simply inapplicable under these facts. We therefore conclude that the November 2020 version of Morton's website fails to support any KRPC 7.1 violations. 2. Clear and convincing evidence does not support the panel's conclusion that the content of Morton's 2021 website violated KRPC 7.1. Morton's July 2021 website is the basis for the remaining violations. Because the panel's final hearing report lacks important details, additional context is again needed. Under the heading titled Associations, Morton included the logo of the Johnson County Bar Association, Kansas Bar Association, and American Bar Association. Her website also used the word experience several times. It is said that you need an experienced Johnson County, Kansas attorney. That attorney, T. Morton, has the experience necessary to determine if you are being treated fairly. That experience counts, and that Morton was experienced legal counsel you can trust. Finally, Morton listed her practice as criminal defense and personal injury. She listed several types of cases within those areas: crimes, bad stuff, auto accident, motorcycle accident, wrongful death, serious injuries. The panel found that these communications were intentional misrepresentations about her bar membership, her experience, and her practice. We disagree with the panel. First, a misrepresentation must be material to be false or misleading. Although Morton's membership in each of the bar associations had lapsed, she had been affiliated with each previously, and her website did not expressly say that she was a current member. So the evidence does not clearly and convincingly establish that a misrepresentation of fact was material. Second, while an attorney's assertion of experience may be material misrepresentation in some cases, that is not the case here. Morton's claims to be experienced legal counsel and to have the experience necessary to determine if you are being treated fairly are not demonstrably false under the record before us. Finally, it is not improper for an attorney to state the areas he or she is willing to practice in, or to state the types of cases he or she will accept. Indeed, KRPC 7.4a specifically allows a lawyer to communicate the fact that the lawyer does or does not practice in particular fields of law. Nothing in the record shows that Morton claimed to be a specialist in a particular field of law, or that she claimed to have experience handling particular types of cases. She simply listed types of cases she would accept. Thus, clear and convincing evidence does not support the panel's conclusion that the July 2021 website violated KRPC 7.1. B. Clear and convincing evidence supports the panel's conclusion that Morton violated KRPC 8.1 by omitting material employment information on her 2016 Kansas and 2019 Colorado bar applications, and by failing to disclose to Colorado attorney admissions authorities that she was facing a disciplinary complaint in Kansas. KRPC 8.1 prohibits an applicant from admission to the bar or a lawyer in connection with a bar admission application from knowingly making a false statement of material fact or failing to disclose a fact necessary to correct a misapprehension known by the person to have arisen in the matter, or knowingly failing to respond to a lawful demand for information from an admission or disciplinary authority. The panel concluded that Morton had violated the rule when she, 1, intentionally failed to include her employment with the Boys and Girls Club, as well as her employment with Crystal Specialties and Colorado State University Pueblo in her Kansas bar application. 2, stated that in her several applications to the Colorado bar that she had voluntarily quit her employment with the Boys and Girls Club and had not been a member of any bar associations. And 3, had failed to disclose this disciplinary case to the Colorado Attorney Admissions Authorities. We addressed these violations in order, noting that neither the panel nor the parties have addressed how each alleged violation fits into subsection of KRPC 8.1. First, we mostly agree with the panel's conclusion about Morton's failure to disclose prior employment on her Kansas bar application. Question 22 of the Kansas bar application required Morton to disclose 10 years of employment history. Morton filed her application in March 2016, meaning she needed to disclose all employment dating back to March 2006. Morton was an employee of the Boys and Girls Club in late 2007, so she needed to disclose that employment. That omission was material because Morton's supervisor testified that she was fired for misconduct, and employment misconduct is one of the factors considered when establishing character and fitness qualifications for the Kansas bar. And because Morton had listed her Boys and Girls Club employment on her earlier Colorado bar applications, it is reasonable to infer that she intentionally omitted it from her Kansas application. Even so, we disagree that there is evidence on the record suggesting that Morton's failure to disclose her employment with Crystal Specialties or Colorado State University Pueblo must be material, so those omissions do not support the violation. Second, the panel relied on statements from Morton's several Colorado bar applications. It should have relied on Morton's 2019 Colorado bar application. KRPC 8.1 applies to a Kansas lawyer or an applicant for admission to the Kansas bar, and Morton was neither before 2016. But we agree that clear and convincing evidence supports the panel's conclusion that Morton's statement on her 2019 Colorado application that she voluntarily quit her Boys and Girls Club position was a false statement of material fact. Based on her supervisor's testimony, clear and convincing evidence supports the panel's finding that the Boys and Girls Club terminated Morton for misconduct, meaning that Morton misrepresented the resolution of her employment relationship. And because misconduct in employment is one of the factors considered when establishing character and fitness qualification for the Colorado bar, it is reasonable to infer that Morton intended to cover up the grounds for her termination. However, we disagree with the panel that Morton's statement about her prior bar membership supports a violation of KRPC 8.1. True, although Morton stated on her 2019 Colorado bar application that she had not been a member of any bar associations, Morton had been a member of the Johnson County Bar Association and Kansas Bar Association from 2016 to 2017 and the American Bar Association from 2013 to 2018. But nothing in the record suggests that Morton's statement was material to her bar application. She was not a member of these associations at the time of her application was submitted to the Colorado authorities. Finally, we agree with the panel that Morton violated KRPC 8.1 by failing to disclose her Kansas disciplinary complaint to the Colorado Attorney Admissions Authorities while her 2019 Colorado bar application was pending. That application asked if the applicant was the subject of any complaints or disciplinary or grievance actions. Morton answered no, which was accurate when she submitted the application in June 2019. But when she submitted the application, Morton acknowledged that she had a continuing obligation to timely update the information on the application until she was admitted to practice in Colorado, and she acknowledged that the amendment was considered timely when made no later than 10 days after any occurrence that would change or render incomplete any answer on her application. As a result, when Morton learned of the pending Kansas complaint against her February 2021, she needed to timely update her Colorado bar application, which was still pending. Her failure to do so was a material omission. Clear and convincing evidence supports some violations of KRPC 8.4c and G, but the panel's findings concerning conduct occurring before Morton was licensed in Kansas do not support a violation of KRPC 8.4. KRPC 8.4 defines professional misconduct. Under 8.4, it is professional misconduct for a lawyer to engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Under 8.4G, it is professional misconduct for a lawyer to engage in conduct that adversely reflects on the lawyer's fitness to practice law. The panel concluded that Morton had violated these provisions in numerous ways, and it relied on the same findings to support violations of both subsections KRPC 8.4. But there is a problem with many of the panel's conclusions. 8.4 expressly applies to a lawyer, and much of the conduct the panel relied on concerns Morton's Kansas bar application, meaning it occurred before Morton was admitted to the bar. As the disciplinary administrator concedes, 8.4 does not apply to that conduct. Thus, Morton's failure to disclose facts on her Kansas bar application about her employment at the Boys and Girls Club, Crystal Specialties, the Colorado State University Pueblo, cannot support a violation of 8.4. Several of the remaining violations involve statements or omissions on her Colorado bar application that we discussed above. Although the panel did not specify whether it found violations based on Morton's earlier Colorado bar applications, 8.4 applies only to statements or omissions made on Morton's 2019 application, since she was not a lawyer when she submitted the earlier applications. We agree with the panel that clear and convincing evidence supports a KRPC 8.4 violation for Morton's statement that she voluntarily quit her employment with the Boys and Girls Club. Her supervisor's testimony clearly and convincingly supports the panel's findings that Morton was fired for misconduct. Morton's statement involves a material misrepresentation and adversely reflects on her fitness to practice law. We also agree that clear and convincing evidence supports a KRPC 8.1 violation for Morton's failure to disclose her Kansas disciplinary complaint to Colorado attorney admissions authorities while her Colorado bar application remained pending. The record shows that Morton acknowledged that she had a continuing obligation to update the information on the application until she was admitted to practice in Colorado. Her failure to disclose the complaint is a material misrepresentation or deceitful, and it adversely reflects her fitness to practice law. But we disagree with the panel that other statements and omissions in her 2019 Colorado bar application support KRPC 8.4 violations. We have already discussed Morton's statement that she had not been a member of any bar associations. The record contains no evidence suggesting that Morton's statement was material to her bar application, so clear and convincing evidence does not support a conclusion that she made a material misrepresentation or that her statement adversely reflects on her fitness to practice law. Nor do we believe clear and convincing evidence supports the panel's conclusion that Morton violated KRPC 8.4 C and G because she failed to disclose to the Colorado bar that she had been employed by El Pueblo. To the contrary, the first item listed in her employment history section of Morton's 2019 application was her position as a principal at El Pueblo. Finally, the panel relied on the contents of Morton's website that concluded that Morton had engaged in conduct involving dishonesty, fraud, deceit, or misrepresentation under 8.4C and in conduct that adversely reflected on her fitness to practice law under 8.4G. We have already addressed most of the content on Morton's website. We determined that there was no clear and convincing evidence showing Morton's use of the Martindale-Hubbell AV preeminent as anything other than inadvertent or at most negligent. We also determined that Morton's use of the 3 bar association logos was not a material misrepresentation, or her use of experienced was not demonstrably false, and that listing case types and practice types was unobjectionable under the facts here, because the record shows that any misrepresentations related to the content were either immaterial or at most negligent. We do not believe clear and convincing evidence shows that Morton engaged in conduct involving dishonesty, fraud, deceit, or misrepresentation under KRPC 8.4C. And for that reason, we also conclude that Morton did not engage in conduct that adversely reflects on her fitness to practice law under KRPC 8.4G. But we have yet discussed Morton's use of the Roth-Davies material because we concluded that such content did not represent a communication about Morton or her services under KRPC 7.1. KRPC 8.4 contains no such limitations, so we agree with the panel that it may sometimes apply when a lawyer misappropriates material for a professional website, but the record before us contains no evidence showing that Morton's use of the Roth-Davies material was anything more than inadvertent negligence. Thus, we discern mistake rather than malevolence, and cannot agree that the clear and convincing evidence establishes that Morton engaged in conduct that involved dishonesty, fraud, deceit, or misrepresentation under KRPC 8.4C, or that adversely reflects on her fitness to practice law under KRPC 8.4G. 4. The appropriate discipline is published censure. We have evaluated the hearing panel's conclusions on Morton's rule violations. We determined that Morton violated KRPC 8.1 by failing to disclose her Boys and Girls Club employment on her Kansas bar application by materially misrepresenting the termination of her Boys and Girls Club employment on her 2019 Colorado bar application, and by failing to inform the Colorado attorney admissions authorities of a pending Kansas disciplinary complaint. We determined that the same conduct violated KRPC 8.4 C, and G, but we reject any of the rule violations the panel found, including all violations of KRPC 7.1 and 8.4 that arose from the content of Morton's website. Violations of KRPC 8.1 and 8.4 that arose from the immaterial admissions of employment and bar membership history, and all violations of 8.4 that arose from conduct before Morton was admitted to the bar. The remaining question is the appropriate discipline. We generally look to the American Bar Association standards for imposing lawyer sanctions to aid in determining discipline. That framework considers 4 factors in determining punishment. 1, the ethical duty violated by the lawyer. 2, the lawyer's mental state. 3, the actual or potential injury resulting from the lawyer's misconduct. And 4, the existence of aggravating or mitigating factors. The panel considered these same factors and determined that Morton had violated KRPC in numerous ways. It found that Morton's violations were intentional and had caused injury and harm to the justice system and the practice of law in Kansas. The panel also found that Morton's misconduct was aggravated by a dishonest or selfish motive, by her commission of multiple offenses, and by her refusal to acknowledge the wrongful nature of her conduct. But it did find that her misconduct was mitigated by a lack of prior disciplinary record and by her inexperience in the practice of law. Based on these considerations, the panel recommended an indefinite suspension with various conditions for reinstatement. The disciplinary administrator recommends we disbar Morton for the practice of law. Morton recommends either censure or probation. While we agree with the panel that Morton engaged in intentional rule violations, we have concluded that clear and convincing evidence supports only a few of the rule violations the panel found. The record also lacks evidence of concrete or specific harm, and the disciplinary administrator has never alleged that Morton injured a client. And we question the weight the panel assigned some of the aggravating factors. We agree that Morton at times acted with a dishonest motive. And while we also agree that Morton committed multiple violations, the aggravating factor warrants much less weight since we determined that most of the violations involving misrepresentations are not supported by clear and convincing evidence. Moreover, in our view, the panel's findings that Morton had refused to acknowledge the wrongful nature of her conduct is not supported by clear and convincing evidence. The panel failed to identify specific instances of Morton's failure to take responsibility, and the finding threatens to punish Morton for exercising her right in an adversarial proceeding. The record shows that Morton promptly addressed the disciplinary administrator's objections to her website, and at oral argument, Morton acknowledged mistakes and evinced a commitment to future compliance. On the other hand, we agree with the mitigating circumstances the panel found. In any given case, this court is not bound by the recommendations from the hearing panel or the disciplinary administrator. Each disciplinary sanction is based on the specific facts and circumstances of the violations and the aggravating and mitigating circumstances presented in the case. Because each case is unique, past sanctions provide little guidance. Having considered the facts here, a majority of this court holds that published censure is the appropriate discipline. We base this determination on ABA Standards 5.13, reprimand generally appropriate when lawyer knowingly engages in conduct that involves dishonesty, fraud, deceit, and misrepresentation that causes injury or potential injury. A minority of the court would impose more severe discipline. Conclusion and discipline. It is therefore ordered that Tereshawn D.D. Morton is disciplined by published censor to be published in accordance with Supreme Court Rule 225A5 for violating KRPC 8.1, 8.4C, and G. It is further ordered that the cost of these proceedings be assessed to respondent and that this opinion be published in the official Kansas reports. Because this was a published opinion, several different legal publications picked it up and wrote about it, which also included noting that Attorney Morton was censured. Beyond that, it was published in the attorney discipline cases on the Kansas Judicial Branch website. And then everything went back to normal. If you actually made it this far, then wow, kudos to you. Please take a moment, subscribe, and leave me a comment. I appreciate your support, and I will see you next time.